Good. So you're all very welcome to this Newman Centre online public lecture of the Autumn 2021 series. And I'm delighted to welcome our speaker this week, Dr. Maeve O'Rourke from National University of Ireland, Galway. Dr. O'Rourke is an Irish human rights lawyer known for her involvement in seeking access for survivors and adopted people to their own personal data, and the publication of appropriately anonymised administrative files contained in historical abuse archives in Ireland, including the archives of the Commission of Investigation into Mother and Baby Homes, the Ryan Commission, and the McAleese Committee that inquired into Magdalene Laundries. As of 2020, she lectures in human rights law at the Irish Centre for Human Rights in NUIG. She's a member of the Justice for Magdalene's research, and she campaigns on behalf of unmarried mothers and children. She's represented victims before the Irish Human Rights Commission and numerous United Nations human rights treaty bodies. And I'm absolutely delighted to have her as a speaker today. And she'll be speaking on mother and baby homes, Magdalene Laundries, and survivors' call for an all-Ireland human rights-based response. Thank you very much, Dr. O'Rourke.
Okay, thanks a million, Dan. And I'm really glad to be here. I can't see anyone else who's here, although, oh yes, I can see a participants list, which is lovely. So thanks a million for coming along. And I hope this is interesting to anybody who's catching up on the recording version. So I suppose I just want to begin by saying that I'm very grateful actually to the UCD School of Law, which is where I gained my undergraduate degree in law, for the constant support actually of the work that I've done over the past 12 years, for setting me on this course, I suppose. And I also had the privilege of lecturing there while doing my PhD a number of years ago now. But it's meant a lot to have that support, and also to Professor Bagramian for hers too, and everybody at the School of Philosophy. So I really appreciate that, and I'm very grateful to be here today. So the topic of my presentation today is the work that I actually spent a great deal of this year undertaking as a member of an independent, what was called Truth Recovery Design Panel, appointed by the Northern Ireland Executive in March 2021. And I'm just going to put into the chat the link for the website for this panel, which is also where you will find, although it's kind of hard to find on the website, so I'm going to put here the report that we published in October. And that work of the Independent Truth Recovery Design Panel in Northern Ireland concerned the question of how to design a truth-telling framework side by side with survivors and relatives of the deceased regarding Northern Ireland's Magdalene Laundries, mother and baby institutions, workhouse institutions, and needless to mention, as the survivors and relatives emphasised, all of their myriad practices and related institutions, including, of course, the adoption system generally, and crucially, the cross-border and even international aspects of their practices. To give a little bit of background to, I suppose, why I was requested to participate in this work, my interest and involvement in advocating for and researching questions of justice for so-called historical abuses in Ireland goes back to 2009-10, when I was a master's student at Harvard Law School, having just graduated from UCD. And it was the summer that the Ryan report was published. And I was extremely interested as a 22-year-old aspiring human rights lawyer in what had emerged. But really, I was very green, I suppose you could say. And it was all new to me. And I just remember saying actually to my parents that summer, I don't know why I'm going anywhere to work on human rights. And immediately on getting to America, wanting to delve into this reckoning with church-state abuse in Ireland. And because I was also interested in women's rights and taking a very intensive course on sex equality with Catherine McKinnon at Harvard, I immediately landed upon the Magdalene Laundries. The fact that those institutions have been left out to date from the reckoning that I was so aghast at, and through my research and wanting to focus on this topic for my master's in law thesis, I came across Professor Jim Smith at Boston College, who was working with Associate Professor Catherine O'Donnell in the School of Philosophy here in UCD, and with Mary Steed and Claire McGettrick as the small group Justice for Magdalenes. And so since 2009-10, I've actually used my academic legal research and then going on to practice as a barrister, as a junior barrister, my legal skills in the realm of pro bono research and advocacy in relation to the Magdalene Laundries in Ireland, and then moving in to the sphere of the mother and baby homes and adoption. And so for anybody who doesn't already know about the work of Justice for Magdalene's research, the website is there. And more recently, alongside Justice for Magdalene's research and Adoption Rights Alliance, I set up in 2015 an initiative with the international law firm Hogan Lovells called the Clan Project, and with Claire McGettrick in particular. And we assisted over 80 people to give full legal witness statements to the Mother and Baby Homes Commission of Investigation, and are now involved in supporting 8 High Court judicial review actions in respect of the Mother and Baby Homes Commission of Investigation report, and also in critiquing and drafting alternative proposals relating to access to personal data, to administrative files relating to the whole system of institutionalization and family separation, critiquing and making proposals on redress, and also alongside Dr. Catherine O'Donnell in UCD in particular, and the School of Architecture staff at UCD, working to propose the creation of a national site of conscience, which would be an archive, museum, educational centre alongside social housing and social enterprise, perhaps at the site of the former Magdalene Laundry at Sean McDermott Street, currently in public ownership. And crucially, and something that it was a real privilege to get to potentially move forward in partnership with something equivalent in Northern Ireland. Okay, so that's some background, and the last maybe key point to make about my background is that at the moment I am one of the lawyers on a case, I've put in the link here, by a survivor of a county home, an industrial school and 3 Magdalene Laundries, Elizabeth Coppin, against Ireland, which is currently ongoing before the UN Committee Against Torture, and argues essentially that while Elizabeth Coppin has received some ex gratia payments in relation to her experiences in the industrial school and in the Magdalene Laundries, because that is how the government, that's how it creates its redress schemes, as a favour, i.e. ex gratia, not as a right or in recognition of wrongdoing. That is insufficient justice, and accountability is still lacking. And in particular, in relation to the Magdalene Laundries, which is the focus of this case, in particular, there is a gap in terms of pure acknowledgement of wrongdoing, of human rights violations, but coupled with extensive secrecy and censorship of information, and a failure to investigate, in the sense that the interdepartmental inquiry into Magdalene Laundries was not focused on the question of abuse, was not independent, failed many of the tests for a human rights-based effective investigation, which I'll go on to discuss shortly. Okay, so in terms of what I am going to talk about today, first I'm going to talk about the background to the Northern Ireland Truth Recovery Design Panel's recommendations, how it came to be that this independent panel, of whom I was one member, was established to come up with a design for a truth-telling process relating to Northern Ireland's Magdalene's, mother and baby institutions and workhouses and their cross-border and other practices. Then I am going to actually just detail in very summary fashion some of those cross-border aspects of the institutions and family separation system. I'm then going to discuss the human rights analysis that I felt was a really important precursor to being able to fully support survivors and relatives and adopted people in telling us and in communicating exactly how they would like to see a truth-telling process operate. And finally, fourthly, I'll go into some detail about the recommendations that have now been made, that have, as of November, so last month, been accepted by the Northern Ireland Executive Office in full. And I'll be so glad to discuss, I'm sure questions will arise about the potential for what happens in Northern Ireland in relation to these institutions and practices, which are, of course, all island in nature. So the potential for what happens there to influence how we conceive of, more importantly, how we practice truth-telling and reparation across the island as a whole. And it really was so clear from survivors and relatives that they see these issues, these historical but also ongoing practices, as wholly cross-border, international. They want to include everybody affected, whether they live now in America, in Australia, wherever in the world they are. And they understand so much about what has gone wrong in the ways that truth-telling has ostensibly operated to date over the past decade or 2 decades across the island. And they understand also that what happens here may well have more broader international implications, because, of course, what we're concerned with, while particular to the island, isn't. And how we do truth-telling in relation to gross and systematic human rights violations, and particularly in settled democracies, really is only an emerging notion. The idea that human rights would apply, that transitional justice concepts would apply, is only something that we're, I think, at the beginning of starting to understand and parse out. Okay, so first of all, the background. How did we get to the point where there are now recommendations newly accepted by the Northern Ireland Executive Office in relation to truth-telling and reparation for the Magdalene Laundries, the mother and baby institutions, and the workhouse and related abuses? So upon the publication of the McAleese Committee's report in 2013, which was to do with the Republic of Ireland's Magdalene Laundries, Amnesty International Northern Ireland office was approached by women campaigners to support their call for justice in relation to Northern Ireland's Magdalene Laundries. This advocacy by these women, by Amnesty International, was followed by a report or recommendations by the UN Committee Against Torture in 2013, when it was conducting its periodic examination of the UK. So for every treaty that a state signs up to within the UN human rights system, there is an independent group of experts that monitors the state's progress under that convention on a periodic basis. I and my colleagues in Justice for Magdalenes used the UN Committee Against Torture periodic review process in 2011, actually, as the first place that we went to within the international human rights system with the issue of the Magdalene Laundries in the Republic. And by 2013, when the Committee Against Torture at the UN was examining the UK's record, and this is across the board under the Convention Against Torture, so not just in relation to an issue, it made recommendations regarding the fact that the recently established Hart Inquiry, also known as the Historical Institutional Abuse Inquiry in Northern Ireland, was only including children and therefore was excluding the experiences that women in Magdalene Laundries in Northern Ireland had gone through, and was also excluding clerical abuse as a question for investigation. 2 months after the Committee Against Torture's recommendations to the UK to ensure investigation and reparation regarding the Magdalene Laundries, the UN Committee on the Elimination of Discrimination Against Women issued a similar recommendation. And by June 2017, and this is following then the Republic of Ireland's establishment of a Mother and Baby Homes Commission of Investigation, a group called Birth Mothers and Their Children for Justice in Northern Ireland had launched a campaign for a public inquiry into mother and baby institutions in Northern Ireland. After this, by March 2018, an interdepartmental working group in Northern Ireland, that is consisting of civil servants, had appointed a number of academics at the University of Ulster and Queen's University to conduct preliminary research into the Magdalene Laundries and mother and baby institutions in Northern Ireland. And that was Dr. Leanne McCormick, Professor Sean O'Connell, with Dr. Olivia Dee and Dr. John Privilege. And the institutions that they were asked to focus on were 4 Magdalene Laundries, 3 Roman Catholic, run by the Good Shepherd Sisters, 1 Protestant, run by the Salvation Army, 7 mother and baby institutions, 2 run by the Good Shepherd Sisters, 1 by the Legion of Mary, and 4 Protestant, including 1 run by the Salvation Army, and 3 health and social services or charitable institutions, including Bernardo's. And while this academic research was in progress, in June 2019, the UN Committee Against Torture again published observations on the UK's record under the Convention Against Torture and called for an impartial and effective investigation into the practices of Magdalene Laundries and mother and baby homes in Northern Ireland. And referencing this, Belfast City Council shortly afterwards in 2020 passed a motion regretting Northern Ireland's refusal to conduct a human rights compliant public inquiry into near identical institutions in this jurisdiction, referring of course to the fact that there had been inquiries in the Republic of Ireland. And that academic research was initially submitted to government at the end of 2019, but ended up going through quite a protracted, what's known as Maxwellization process, where the right of reply is offered to the institutions alleged to have done wrong, and this went back and forth, and it was ultimately finally submitted in December 2020, published in January 2021, and that's then what gave impetus to the creation of the independent panel to work with survivors and relatives to design an investigative framework. Because the academic report is preliminary in nature, it contains extremely important original oral history testimonies. It notes the academics' difficulties in getting fully to the bottom of some factual questions due to inconsistent record keeping. It doesn't make recommendations, but it's an essential first step in the historical research. And it does stress the importance of further research and preservation and access to records. Okay, so then I suppose March 2021, an independent panel was established. My co-panelists were Professor Phil Scraton, Professor Emeritus of the School of Law in Queen's, and Deirdre Mahan, the Director of Women and Children Services for the Western Trust Social Care Board in Northern Ireland, or sorry, for the Western Trust in Northern Ireland, and the Executive Director of Social Work in Northern Ireland. Just to give you very brief detail on how we conducted the process of working with survivors and relatives to make recommendations as to how an investigation should proceed, because that is what we were asked to do, to design options for an independent investigation or inquiry into mother and baby homes and Magdalene Laundries in Northern Ireland, identifying a preferred option, providing robust rationale in conjunction with victims and survivors of the institutions through a co-design process. So 186 people directly affected by the institutions registered their interest in actively participating in our design process. Others were in touch but said they didn't want to be directly involved, but requested that they be updated on progress. They helped us to design the call for participation in our work. We consulted, and people directly affected inputted into the nature of the questionnaire that we used. We, in addition to a questionnaire, ran online meetings, telephone consultations, large group meetings, individual meetings, a constant contact mailing list with regular updates to be sent. And of course, there was the ad hoc receipt of emails and phone calls from time to time by anybody who wished to get in touch. And 3 weeks prior to concluding, we had a final online meeting and individual phone conversations were preferred to share the proposed recommendations and content of the report, which did enable further refinement, as you can imagine, in the course of the meetings, but also in follow-up afterwards over email. And I think the last thing I want to say in that kind of preliminary description of how this process came about, which was really important to see, and I felt, I thought it was profoundly important actually, that it seemed to me that the people who were interacting with us were extremely well informed about the downsides of how the investigative process has been undertaken previously, whether in Northern Ireland or in the Republic of Ireland, whether that be, for example, experiencing in the Hart inquiry, which was, of course, the inquiry into childhood residential institutions in Northern Ireland, the fact that it did not automatically give survivors core participant status in the inquiry, meaning that they then didn't obtain legal assistance. They were left without access to key personal data that may have then just been revealed to them directly in advance of giving their evidence or through the course of being cross-examined or being examined on their evidence, whether that be the very adversarial nature of the redress board that operated alongside the Commission to Inquire into Child Abuse here in the Republic of Ireland, the fact that the Magdalene Laundries investigation in Ireland didn't even have as part of its mandate to investigate abuse, rather it was solely concerned with the question of state involvement with the institutions, the secrecy of records gathered by the Ryan Commission on Industrial Schools here, the Magdalene Laundries inquiry by the MacLeese Interdepartmental Committee, or the Mother and Baby Homes Commission. Of course, so many people are affected by numerous institutions. And so people either had personal experience of failings of previous processes, or simply because it is becoming, I suppose, more of an open topic and people are becoming far more informed, they had knowledge of what other people had experienced and what they did not want this process to be. And that, to me, signals progress, and that it has been worthwhile for people who have been badly affected by previous inquiries to speak out about how they have found the experience of, most recently, for example, having given evidence to the Mother and Baby Homes Commission investigation and then having to sit through a report that finds no evidence or very little evidence of forced adoption, of incarceration, of forced labour, of everything that they know to have occurred to them and to other people in the institutions. So that was one thing that I just experienced from the off, which I thought was extremely important. So to move just to a few of the details of the cross-border aspects, which the people directly engaging with us were at pains to highlight. According to the work of Leanne McCormick and Sean O'Connell in that academic research report, an estimated 11.5% of girls and women who entered mother and baby institutions in Northern Ireland had home addresses in the Republic of Ireland. In the other direction, the Mother and Baby Homes Commission of Investigation found that mothers in the Castle Hostel in Donegal, in Dunboyne Mother and Baby Institution, in Denny House, in Bethany Home and in Bessborough had been transferred from Northern Ireland. In relation to the Magdalene Laundries, Leanne McCormick and Sean O'Connell found through their assessment of available records that in the Derry Magdalene, an estimated 30% of the girls and women appear to have come from the Republic of Ireland, many through referral by the Sisters of Mercy at the Stranorlar County Home, which functioned as a mother and baby institution. And they also found evidence that a magistrate in Donegal used the Magdalene Institution in Derry as an alternative to prison. In relation to the Belfast Magdalene Laundry, approximately 14% of girls and women appear to have been transferred there from the Republic of Ireland. And there was evidence that they found of transfer of a girl by the Sisters of Mercy in the Republic of Ireland to the Magdalene Institution in NUIG. Also evidence of the transfer of girls and women by the Good Shepherd Sisters in Northern Ireland to the same congregation's convents in the Republic of Ireland. And in terms of cross-border adoption, the academics report found that a significant number of children born to mothers resident in a mother and baby home in Northern Ireland were adopted in the Republic of Ireland and in other jurisdictions. And that between 1957 and 1982, 202 babies were sent from Marionvale, which was a Northern Irish mother and baby institution, to baby homes, is what the academics termed it, in Stamullen, County Meath, Vaughan, County Donegal, and other institutions in Dublin. And from these locations in the Republic of Ireland, many adoptions were arranged, including of children to America. And the academics in their report made the point that far more research is needed into these transnational adoptions, and the legality of them remains seriously in question. We, as the panel, also received information from Conal O'Flaherty, journalist and academic lecturer in NUIG Galway, of cross-border adoption in the other direction. He highlighted that until 1994, hundreds of children were sent from the Republic of Ireland to Northern Ireland for adoption. He notes that the Adoption Authority of Ireland had told him, or has stated, that it does not have sufficient information on each of these children to be able to confirm the legality of all those adoptions. And the Mother and Baby Homes Commission of Investigation report also demonstrates that some of the children born in Pelletstown, Bessborough, Castlepollard, Bethany Home, Denny House and Dunboyne in the Republic of Ireland were transported to Northern Ireland for adoption. Okay. So moving, and I suppose, before I leave the issue of the cross-border facts. You are probably thinking already, of course, this raises issues and potential huge problems regarding access to information for the purpose of an investigation in Northern Ireland. And then on the other hand, it has the potential to, I suppose, what happens in Northern Ireland has the potential to reinvigorate and change the practice and the very unfortunate and problematic practices that we have seen to date of a lack of access to information and a withholding of information that people are legitimately seeking for their own personal purposes, and that is also needed for the purpose of investigation. So to move to the human rights analysis, this, I suppose, was a primary and preliminary concern of mine to do sufficient research into the human rights situation, something that I've been researching for a very long time now, but such that we would fully facilitate survivors and relatives in articulating and in fully excavating the extent of what they need to see by way of a truth-telling process. I actually published on the website of the Truth Recovery Design Panel a separate background human rights analysis, which I'm just putting in the chat here, which informed our work, but was just too long and detailed to ever be inserted into the final report itself. But I hope that it might be of interest to some of you. And it certainly was of great use to us as the panel in ensuring that we were implementing that state obligation to consider and to act to vindicate human rights, even in that small but hugely crucial job that we were doing. I just wanted to make sure that we were leaving no stone unturned, and that we weren't leaving out any potential function of a truth-telling process in the questions that we were asking people to answer, in the suggestions that we were making, in the examples that we were giving of how a truth-telling process can operate. And I suppose my analysis focuses on two things in particular. The first is the substantive continuing human rights abuses that any funded, dedicated initiative of any sort by the state now should seek to cease. So I think we've seen in the past investigations that operate, and even just general public narratives that proceed as if the abuses we are concerned with here are solely historical. In fact, and perhaps particularly in relation to, of course, mother and baby institutions and adoption, the substantive human rights violations are in very many cases continuing. And it is, of course, a basic requirement of human rights law that the state would cease these continuing substantive human rights violations. And so I was extremely concerned to focus on what those are, so that it would be at the forefront of the purposes of an inquiry to do what it can to cease any ongoing situations of human rights abuse. The second key aspect of the human rights analysis is relating to what a human rights-based investigation is. Often talked about, but what actually is it? And there is a lot of law, whether it be the case law of the European Court of Human Rights, which implements the Council of Europe European Convention on Human Rights, which of course still applies to the UK, even though no longer a member of the EU. Or whether it be the jurisprudence of the UN human rights treaty bodies, or the content of any number of documents drafted by UN special rapporteurs that have the authority given to them by the UN Human Rights Council as special procedures to issue expert interpretations of what human rights law requirements amount to in any given context. So there is a lot about what an effective investigation means under international and European human rights law, and that's the second aspect of the analysis that I wanted to get to the bottom of and to share with survivors and to use as a checklist to make sure that we weren't missing anything in what we were asking survivors and relatives to consider. And I will say that despite that European and international human rights law body of human rights law being quite developed, it still doesn't get to the level of detail that the survivors and relatives get to themselves. And it's worth saying that because, you know, it's important at all times to be conscious of the paramount expertise of the people who are personally affected, and the importance of paying attention to the fine-grained detail of what they know to be required in any given context. So, okay, so just to turn to the first issue then, which is the continuing substantive human rights abuses that any inquiry designed should pay attention to ceasing. The first that I look at in that paper, and there's a shortened version of the paper, I suppose, which combines its key points with the empirical evidence gathered in the oral history testimonies by the academics who came before us in the actual report in chapter 2. So the first thing that it looks at is disappearances. So an enforced disappearance is defined in international human rights law as occurring when a person is arrested, detained, or abducted against their will, or otherwise deprived of their liberty by state authorities or with the state's support, consent, or acquiescence, following which the state refuses to disclose the person's fate or whereabouts to their relatives. And the European Court of Human Rights, in a case that's particularly relevant to the situation of mother and baby institutions and adoption in Ireland, found in a case in 2013 called Jovanovic in Serbia, that a disappearance had occurred where a woman's newborn baby was taken from her in a state-run hospital, and 32 years later, her baby's body still hadn't been released to her and she did not know the cause of death or burial place. So while enforced disappearances are usually, of course, understood to occur in situations of civil war or political strife, there's absolutely nothing to say that that definition doesn't apply to the situation that girls and women were subjected to in the institutional and forced family separation system in Ireland. And there is evidence, and I quote it in chapter 2 of the main Truth Recovery Design Panel's report, in the oral history testimonies that are contained in that 2021 report of Leanne McCormick and Sean O'Connell that go directly to the legal definition of an enforced disappearance. And it's also worth noting, in addition to the oral testimony, the academics in their report noted that the religious orders records for Magdalene Laundries do not fully demonstrate who died in the institutions and where they're buried, because burial lists provided by the nuns to Leanne McCormick and Sean O'Connell do not fully match the records of the women that the nuns provided. And many women who died in the institutions are interred in unmarked graves. In addition to disappearances, I focused on the ongoing human rights violation of unlawful denial of identity. And that is to say, the ongoing interference with the right to access information about one's basic identity at birth, and also personal history as a child in state care both of which have been recognised by the European Court of Human Rights to be fundamental to the right to respect for private and family life under Article 8 of the European Convention on Human Rights. Of course, the right to respect for private and family life is not an absolute right, but under the European Convention on Human Rights, which has the formulation that is common across international human rights law generally, and for example, under Irish constitutional law, the state may only interfere with the right to respect for private and family life if, number one, it does so based on clear legal rules which prevent abuses of power, and number two, it does so only where necessary and proportionate in a democratic society for a legitimate public interest purpose, such as protecting the rights and freedoms of others. And over the past 3 decades, Northern Ireland adoption agencies, including health and social care trusts, have used 1989 adoption agencies regulations to guide their information disclosure practices. And these regulations give adoption agencies full discretion to, and I quote, provide such access to its case records and indexes and disclose such information in its possession as it thinks fit for the purposes of carrying out its functions as an adoption agency and to a person who is authorised in writing by the department to obtain information for the purposes of research. So this, as you can tell, is an unfettered discretion, a result of which is victims, survivors, and adopted people continuing to experience wholly inconsistent practices dependent on the views of the person or agency responding to their information access request. And there's a lack of transparency over the adoption agency's disclosure practices. And beyond adoption agencies, there's no regulation to specify the disclosure obligations of the religious and other non-state organisations that operated and interacted with mother and baby institutions, Magdalene Laundries, and workhouses. And since 2018, the Data Protection Act 2018 and what was the EU GDPR, but is now the UK GDPR, they have technically overridden this adoption agency's regulation. And now that broad data protection law, the Data Protection Act and the UK GDPR apply to the information disclosure practices of all state and non-state controllers of adoption records. And so in theory and on paper, adopted people and everybody affected by the institutional family separation system has a right to obtain all of their personal data, and personal data includes information that relates to you and somebody else at the same time. The fact that it relates to you as well as someone else at the same time does not affect the right of either of you to access. It remains the same. And again, going back to European human rights law, it is only permissible to interfere with that right where there is clear legal basis for doing so and where it is necessary, demonstrably necessary and proportionate in a democratic society. And so what we say in our report as a result of this analysis is that there is, it would seem, insufficient legal guidance to justify the very widespread redaction practices of the various data controllers. And it's worth noting that Article 8 of the UN Convention on the Rights of the Child states where a child is illegally deprived of some or all of the elements of his or her identity, states parties shall provide appropriate assistance and protection with a view to re-establishing speedily his or her identity. And so moving on to the requirements of a human rights-based effective investigation, it is all in a combination of Chapter 2 of the final report, which I've shared, and my own more detailed background report. But among the requirements that have been established either by European human rights jurisprudence, that is case law, or the international documents of various expert bodies or cases of the UN treaty bodies, are requirements such as people directly affected being involved in the design of investigations, promptness, the purposes of the investigation, including, of course, establishment of the facts, but importantly, establishment of state, as well as institutional and individual accountability. Very importantly, individualized investigation of the circumstances of a person's death and their whereabouts, the fate of disappeared persons. Also very importantly, archival preservation and access, and essentially as well, contribution to the effective functioning of other justice procedures and measures of redress. There are standards to do with the characteristics of the investigators, the powers of the investigators, including in terms of characteristics that there would be gender balance, knowledge of gender issues, in terms of powers, full powers to compel evidence, the importance of protecting archives, and standards to do with the state's provision of adequate resources. There are standards to do with responsiveness to people who are directly affected in terms of comprehensively addressing gender-based and other forms of discriminatory abuse, adopting an intersectional perspective sensitive to, of course, the compounding and particularized effects of multiple forms of discrimination, and providing flexibility within terms of reference so that they can adapt over time, or so that an investigation can request the change to its terms of reference where that is deemed necessary. Procedural fairness, of course, is dealt with, importantly, including the right of those directly affected to obtain all the relevant information necessary to enable them to fully participate in the investigation. Issues around protection of victims from re-traumatization, seeking written statements as a first step, acknowledging that while proceedings should generally happen in public, private proceedings may be necessary, standards to do with public scrutiny, and very importantly, for the purposes of our job, a very clear requirement that an investigation is, of course, a specialized investigation such as a truth-telling commission is, number one, not to take the place of the existing democratic accountability mechanisms, but instead to contribute to their effective functioning, i.e. coroner's inquests, criminal investigations, access to court, freedom of information, national archiving. These things are not to be swallowed up or set aside while a dedicated investigation is ongoing. The purpose of a dedicated investigation includes to contribute to their effective functioning. And secondly, that the effective investigation is part of an overall right to reparation, which includes restitution, where possible, restoration of rights, return of what was taken, which may include identity, family life, citizenship, the proceeds of a person's labour, compensation in proportion to the gravity of the human rights violation suffered, rehabilitation, satisfaction, which is to say effective measures aimed at ceasing violations, verification of the facts, search for the disappeared, official declarations and judicial decisions restoring people's dignity, state apologies, commemorations and tributes, and guarantees of non-recurrence, including institutional reforms and inclusion of accurate accounts of the violations that occurred in education at all levels. So you can see that we were dealing with quite a complex framework, and putting this all to the survivors and relatives and allowing it to, I suppose, inform how we were interacting with them, I think was extremely challenging, but also very rewarding, because I think as somebody who that is myself, I'm just, I suppose from personal reflection, having interacted a lot with UN human rights bodies and human rights litigation over the last decade or so, it is actually the case that the standards emerge from the work at the grassroots and the work of the people who are experiencing human rights violations, be that somebody who decides to pursue a case all the way to the European Court of Human Rights, or be that all of the organisations and victims of human rights violations that speak to the independent experts at the UN who only have those jobs because they're so committed to ensuring the development of best practice. And so actually using all of these standards, I think, worked quite seamlessly with gathering through the questionnaires and all of the other ways of speaking to people affected what it was that they wanted to see. And ultimately, the 5 recommendations that we came up with are, number 1, the adoption of guiding principles, which should influence throughout the implementation of the rest of the recommendations, everything that happens. And in chapter 11 of the ultimate report of the panel, I reference, I suppose this is where we bring in comparative practice from jurisdictions all over the world. So having gone from the principles to then having them informed by what survivors and relatives want, we looked at what and where this had been done. Something similar had been done in the past elsewhere, if at all. And so we see guiding principles being very important in the mandates of the Canadian Truth and Reconciliation Commission and the Canadian National Inquiry into Missing and Murdered Indigenous Women and Girls. Recommendation number 2, that the Executive Office would take overall responsibility for implementing the recommendations because they are so urgent, so diverse, so complex, and they also require the highest level of interaction with the government in the Republic of Ireland. The biggest recommendation was number 3, an integrated truth investigation by both an independent panel, which is established without the need for legislation within 6 months, and a statutory public inquiry being fed into by the work of an independent panel. We have recommendations for constant interaction between the independent panel and a forum of survivors and relatives. And in fact, from the very beginning, that the forum of survivors and relatives would shortlist a list of potential appointees to that independent panel. It's important that a non-adversarial forum is afforded to people who wish to give testimony. And that, of course, is not something that has been experienced in statutory public inquiries, hence the need for an independent panel. A really important aspect of that panel is that one of its primary functions is to help people access information. And another key function of it is to undertake human rights-based systemic analysis. As I mentioned, the statutory public inquiry is the second part of the investigation that we recommend. And included in the recommendations is that while legislating for the statutory inquiry, the government would, through statutory instrument in the rules of procedure, ensure that it is a presumption that anybody directly affected is a core participant, such that they would then be treated like all of the alleged wrongdoers in terms of access to legal representation and access to evidence. The 4th recommendation concerns access to information, an immediate preservation order and legislation to preserve records that are at risk of destruction or loss, guidance to guide data controllers under the existing Data Protection Act, and ultimately legislation that creates a permanent national archive to work in collaboration with a similar sister archive, I suppose, in the Republic of Ireland that makes permanent all of the work that has been done by the independent panel and the statutory inquiry. And we reference examples such as the Canadian Centre for Truth and Reconciliation and the Stasi Records Agency in Berlin. And the final recommendation concerns redress. And as you can imagine, there are many aspects to all of the different services that are required, and references to, for example, a very recent report of a parliamentary committee in Victoria, Australia, to do with the redress required by people subjected to forced adoption. And it is interesting to see just the breadth and the very fine detailed recommendations that come out of processes of listening really carefully to people directly affected. And I have to say, as a final word, so much is to do with pure information access. And it really is distressing and important, I think, so important to recognize that despite decades at this point of supposed truth-telling on the island of Ireland, and indeed in many other jurisdictions, what remains the most intractable issue, which our recommendations really seek to address up front, is the actual continued substantive violation of people's rights, which is the denial of access to information about their own life and the fate of their own relatives. So I will stop there. I hope that that was possible to follow, and that some of the links will help you delve a bit deeper into everything that I've mentioned.
Oh, thank you very much, Dr. O'Rourke. That was a fantastic summary of, well, over a decade of incredible work. And I have to say the moral and intellectual clarity of your thought and your arguments and really just sing through. It's really incredible work. So thank you very much for sharing it with us. We're very privileged. So I'll allow questions in the Q&A. So if you have a question, please do type it into the Q&A function, and Dr. O'Rourke and I will be able to see those questions. So if you want to look at them, Maeve, then you can.
Yeah, and I'm delighted to see too here from members of the law school. So thank you to Ian, of course, for